Next up, we are going to hear from some of our very own Bloomberg Law analysts, the regulatory and compliance team, and they are going to come up and play a little game of Privacy Jeopardy with us. And to continue the interactivity of the entire day, they want to play against you. Feel free to shout out the answers if you think you have them, but remember, it is Jeopardy, so please phrase your answer in the form of a question. All right. Regulatory and compliance team? Here they come.
We had to finish our lunch as well.
Oh, well, they want to eat. What? Oh. You don't want any hangry analysts on stage.
Walk.
Yeah, go ahead. Amanda, Mark, Betsy, Dory, some of my favorite people. I can't wait to play with you.
So, while you all are finishing your lunch, good afternoon. That was a really great opportunity for all of us to have heard from Rep. Walden and to have heard from all of the great panelists that we've had this morning. I think, though, that now at lunch and after lunch would be a perfect time for trivia. And Ask an Analyst, sometimes we've done this panel, Ask an Analyst, where it's been a Q&A, sometimes it's been a little bit of an interview style or a prepared presentation. This time we are absolutely going to have the Bloomberg Law Analyst Regulatory and Compliance Unit, or 3/7 of us, or 4/7 of us, I exist, present to you a little bit of Jeopardy. And we're not, I want to say for anyone who has seen the news, we're not trying to audition for Alex Trebek's job, and we do wish him well. I don't know if, I didn't want any of you to think that this was, mean. Like, Alex Trebek has been doing well and apparently is not doing well again. And it was, yes. We all wish the Canadian well. I like Canadians. All right. So she was doing this before. She's going to keep laughing at me. The contestants that I've got today, unrelated to actual Jeopardy, are Mark Smith. He's my my analyst on data privacy specifically. Betsy Mountainay, who's my expert on health, and Dory Goldstein, my expert on employment. And that might give you a hint as to why the topics that we have on the board are state of the states, health information prognosis, and your employees, their data. I will be controlling the board and making the selections on the slides. This is not a completely live 15-question round. Don't worry, we do have other things to do today. But I am going to let all of you take any of you to take the first stab at answering these questions. Please do make sure that when you answer in the form of a question, or it won't count. If you do get a question correct and you phrase it correctly, there will be a prize. Otherwise, and even if someone does get it right, we will be continuing to have a conversation throughout the rest of the presentation. So right now, let's start with state of the states for 800. Amanda. All right. This state was the first to pass legislation based on the National Association of Insurance Commissioners Insurance Data Security Model Law. No, Meg's not allowed to answer. None of my colleagues are allowed to answer. Does anyone know who the first state was? Oh, okay, we got a not in the form of a question and an incorrect answer. It is not what is New York.
What is Delaware?
Wrong. You all have lost $800 that you can give to me personally on your way out of the room. All right, no one. Mark, do you know an answer?
I do. Do I get the prize?
No.
Oh. Okay. What is South Carolina?
Yes.
Okay.
Okay.
I
so
helped with the,
he did help with this,
yeah.
so he's supposed to know the answer.
That's
also,
why I don't get the prize, right?
Also, Mark helped with the wonderful back wall board that has been mentioned by at least two of our esteemed panelists this morning. Mark, what's going on with the NAIC?
Okay, so the NAIC drafted a model law on cybersecurity practices. It was it tracked somewhat the New York DFS regulation. So there are a lot of cybersecurity type requirements in the law. South Carolina was the first one to enact it, and it's actually the first one that's already gone into effect. As of the July 1st, if you are an insurer and if you are regulated by the insurance commissioner in South Carolina, you should already have your compliance program in effect, your cybersecurity program. The deadline for making sure that your vendors are also compliant is another year down the road, July of 2020. So South Carolina is not the only law. There are 7 other states that have implemented these, and the next one coming into effect will be the one in Ohio.
How do you know so much about the NAIC model law for data security?
Because I track these things. Okay. Yeah.
If any of you are interested also about what he's tracking, Mark did this week write a piece for our Bloomberg Law Analysis channel, specifically about what's happening with this trend right now and how it'll play into some of the larger trends in data protection.
Yeah, and what I think is significant about all of these laws is it's not only your own practices as an insurer, somebody regulated by the insurance commissioner, but also that of your third-party vendors. So that's something that people need to pay attention to. There are already a bunch of laws that apply to vendor contracts. Outside of the insurance sector, it's definitely a growing trend in this area.
And so among the states that have vendor contract-specific data security laws on the books, we've got 50 states, a couple territories. What are some of those?
Well, definitely the most famous of them all is Massachusetts. I think everybody's pretty aware of that. But we've got a nice tracker on Bloomberg Law to keep you abreast in case you're wondering, what sector am I looking for, or what which states have implemented these laws. So.
Okay. And I'm going to read this portion of it just so that I don't get it wrong.
Okay.
The CCPA creates a private cause of action from a breach resulting from a company's failure to implement reasonable security measures. Is there anything similar in the NAIC model law or South Carolina's?
Well, the good news is that these insurance model laws do not have a private cause of action. And maybe good news, maybe not so good news, they don't use the word reasonable. I know lawyers love to have that wiggle room with the word reasonable. In the insurance sector, they're using the word appropriate. So maybe you got some wiggle room there as well. But I think the key takeaway from all of this has to do with documentation. Since you must perform a risk assessment, it's good to have that documented so that when, whether it's going to be somebody suing you under the CCPA or a regulator coming after you in the insurance sector, it's great to have that documentation of here's our risk assessment, these are the risks we identified, and these are the measures we put in place to ensure that we are complying.
And what about the situation where there's a risk you've identified, but there isn't a solution yet?
Well, then you hire one of these in-house counsel.
Oh, is that what you do? Okay.
Yeah.
We've learned everything that there is to know about NAIC. No, there's not, but there is quite a few good tidbits in there. Let's try health information prognosis for 400 Betsy. But first, we are going to give everyone else a chance to answer. This collection agency, serving clients like Quest Diagnostics and LabCorp, was subject to the second largest reported health data breach. Who remembers? You're still not allowed to answer, Meg. Who remembers from this morning also? I'll give you that clue. Pretty sure it was my attorney general who mentioned it. Nothing? Wow. Nope. Well, that was mentioned, but that's not this one. Betsy?
It was. What is the American Medical Collection Agency?
All right, so why did they lose 25 million people's information?
I'm sure there's a lot of forensic experts who are struggling to answer.
I didn't say how, I said why.
I think the problem here is a lack of HIPAA compliance. Okay. What we're seeing here is a business associate of several, I think we're thinking maybe 23 at latest count, and the body count has been rising quite a lot over the summer. 23 healthcare companies doing business with this business associate. They experienced this large breach. It went undetected for about 8 months. The way that it was found out was researchers were uncovering that credit cards numbers were being used, and they were all linked to this particular company. They went undetected for about 8 months, so they started notifying their clients on a pretty slow basis. And it kind of started off as a Quest Diagnostics breach and a LabCorp breach. So it's a really good reminder that breach might happen on a vendor's watch. You might have the appropriate business associate agreement in place, but that's still your if you're a covered entity under HIPAA, that's still your name and your reputation on the line. Things didn't go so well for AMCA. They had to file bankruptcy as a result of losing business with clients like Quest Diagnostics and LabCorp. Also, think about it. You have 25 million people to notify of a breach. The cost of postage alone on that notification is probably going to, lead you to bankruptcy. So we haven't even gotten to enforcement actions with HHS OCR, and they're already going out of business. And I think this is just going to be a really good reminder to covered entities under HIPAA that what they're doing with their vendors, that's on them. They need to be keeping track of this sort of thing. You do have to get a business associate agreement under HIPAA, and there's a template for that on their website. It hasn't been updated since 2013. I think savvy covered entities out there are going to be requiring their vendors to promise a lot more. They're going to want to see cyber insurance. They're going to want to make sure these companies are, doing software updates and patches and things that can protect all their information from breaches. They're going to want to make sure that they're being notified of these things in a timely fashion, and that there's a lot of transparency going on. So I think this is, Congress has threatened to, start scrutinizing these practices. So I think this is really going to maybe mark a change from an enforcement that is really about whether or not you have this business associate agreement signed to, should you really have been doing business with this company? Were you monitoring them? A real change in sort of our vendor practices.
It's not in the notes we prepared for, but I'm interested to put you on the spot because I'm your boss and I can. Do you, in terms of the business associate, whether you should have that business associate or not in the first place, do you, in your experience, you've been doing this for quite a while, do you see the possibility for an enforcement action that just says they're terrible and you should not have been in a relationship with them?
Absolutely, because a part of your HIPAA risk assessment, or risk analysis, you should be looking at this company. You should be doing due diligence. You should be getting them to, certify that they can comply with HIPAA. And if you're not doing that, and you should have noticed all these gaping holes in their security practices, then absolutely, I can see that as definitely a direction we're going in.
Okay, so another direction we're going in, and any of you who have been to another one of the Bloomberg Next events, the Bloomberg Law Leadership Forum, or the in-house events that we have, I have moderated those before, and this is adapted from a joke that I've made, but we're moving the direction of wearables. This ring is, in fact, a wearable, and it's one that doesn't give me a readout, so it doesn't distract me in the middle of the day, which my boss is very thankful for. That's her in the back. Her readout has all of this, emails coming in. Wearables, Internet of Things that it's come up in earlier parts of today's presentation. Other emerging technologies that we haven't really figured out yet. So where does HIPAA fit into those, and the fact that this knows what my heart rate is right now?
So HIPAA only regulates apps and mobile devices and other technology that we're seeing when there's a business associate relationship with a covered entity. So if it's collecting information and then funneling it off to a doctor so that doctor can monitor a patient, then there's probably a business associate relationship there. If it's just tracking how many steps you're taking any given day, and just for your own gratification, that's not a business associate relationship. There's no covered entity involved, and so HIPAA doesn't regulate that. And I think this creates a lot of confusion around consumers because we're seeing a lot of companies highlighting that their devices or their apps are in fact HIPAA compliant. But that doesn't mean that, if Alexa is HIPAA compliant, that doesn't mean Amazon loves us and cares about us so much and they really want to make sure all our data is protected. That just means that they can do business. They have the opportunity to do business with these companies and put an Alexa in hospital rooms and sell an Alexa for every patient bed in a particular healthcare entity. So I think that's creating a lot of confusion. And there's a lot of people who want to do something about that because this information is, health information is, it's sensitive because, people can use it to blackmail, people can use it for embarrassment. It has a longer lifespan than your credit card number. There's social security numbers involved. Those don't go, those don't expire. So this information is really valuable. What do we do? And what do we do with all this healthcare information, though? Some people want to put it under HIPAA, and I think that could create some really strange bedfellows. HIPAA was intended, at a time where the people who had healthcare information were health plans and healthcare providers. That was really obvious. That's changed now. So do you want these devices and apps regulated by the same law and the same standards that healthcare providers, who they're kind of collecting the data as part of what they're doing, but they're mostly, out there to provide care, provide payment for services. Collecting that data is a completely different thing. And it's really hard to draw the line on what apps on your phone are indeed collecting healthcare data. Sure, we know something that's tracking the number of steps you take, or maybe your fertility or something, or your diet. That all is obviously health information. But, the example that comes to my mind is every time my husband goes for a physical, I'm sure the doctor asks him, how many drinks do you have a week? And he says, 3 or 4. And, every day where he goes to the brewery and he has those 3 or 4 drinks in one day, and he puts it on an app on his phone, and he says, how much he liked the double dry hopping and all that stuff. Is that health information if a doctor's not writing it down? I'm sure he doesn't want his doctor to know it. I'm sure he doesn't want his health insurance plan to know it, or a wellness plan at work to know it. It's a more accurate assessment of his health.
And he definitely wants the brewery to know it because he's got bonus points.
Yeah, absolutely. Yeah. He's regular a lot of places. But anyway, what is that? What happens to that information? And so many things on our phone could tell somebody about our mental state, our health. Where are we going to draw the line? So, HIPAA, it is an existing framework. It could be good to cover some of this healthcare data, but maybe it's not the right thing. So it'll be interesting to see how this evolves over time.
Before we get to Dory and the employment, that did actually bring up for me something that you and I had been talking about. You brought up the fact that Social Security numbers and other non-changeable identifying information, it lives longer. So I was reading yesterday about health data, X-rays, MRIs, doctor's notes from appointments that get uploaded into a computer system and then housed on servers. And there are servers that are not password protected, making all of that information about patients accessible to someone with very basic computer skills. That seems like a really terrifying situation where something that is information that's obviously covered by HIPAA and obviously enforceable if there's access to that information by non-medical providers. But it seems like it's happening.
Definitely. When we started looking at the breach information that's been reported to HHS OCR, we expected to be able to start telling everybody who's reading Bloomberg analysis, these are like the big threats that are, coming after you. This is what you should be preparing for. And what we started to find was some of these things that seem so patently obvious. Information being posted in non-protected areas by IT vendors, or mailings going out to the wrong person receiving the wrong person's PHI.
The postcard one.
Like the postcard that says, hey, don't forget to get your colonoscopy again this year, right in the mail that everybody can see it with your address on it and your name. So there's a lot of stuff happening with HIPAA that just seems sort of like really low-hanging fruit. So it's another reason that maybe so the agency that's dealing with doctors sending out postcards and IT vendors that are posting, records in public places that you can access from a search engine, are they the right people to be dealing with things like Fitbits and Alexa that are really sophisticated, hopefully? It's a question we're going to really have to tackle.
Okay. So far we've gotten Mark on the, what states are doing to try to address, large sweeping scope of privacy and data protection laws. We've gotten Betsy scaring us all about the mobile devices and wearables. And so now, to scare anyone in here who's the in-house cohort, specifically, or some of the lawyers who represent those companies, we're going to get some employment context with your employees, their data for 1,000. Are you ready? You remember to give them a chance first. Don't just shout it out.
I guess. Okay.
Fine. This bill would amend the CCPA so that, with some exceptions, it would...
AB 25.
Yes!
Present!
Although, to let you know, when my dad was trying out for Jeopardy, if you buzz in early, they actually penalize you and they make you wait. That's why everyone, it's like you're always in your house. I'm sure a lot of us in here are competitive.
Give her that wine glass.
You totally earned this. You have a Bloomberg Law beverage receptacle for any type of beverage you would like. But yeah, they do penalize you. So if you see someone who's like buzzing in on TV and they're being kept from buzzing every time they're trying to buzz early, which is why my dad didn't ever get on TV for Jeopardy. So yes, that's our answer. What is AB 25? So I'm sure that you could also give some of this background that Dory's about to do. But Dory, would you like to talk to us about AB 25?
I would love to talk to you about AB 25. AB 25 is a bill that has passed the California legislature, and it would delay the enforcement of part of CCPA for 1 year, and only 1 year. And it's not everything. This only applies to data in the employment context. So this is employee information you're collecting on employees, applicants, some cases owners, contractors, all of that. And the part that it delays is that duty to hand it over, to respond to these requests and delete it. It doesn't delay the ability to be sued if there's a data breach, and it doesn't delay your requirement to notify employees that you're collecting data. But I want to say one thing about this from the employment perspective. When I first started getting into CCPA and all of this as an employment attorney, I was like, that's not a big deal. In California, for years, the labor code has required employers to hand over personnel files, wage information, anytime an employee requests it. So why is this more difficult? Like, what's the big deal? Because that part of it, the employment records that you keep in files, it's really easy to send over. We're talking about a much broader scope, as you know. If you have security cameras, it's those images on those security cameras. Every piece of software that you can log when an employee walks in or logs into it. If you have a security badge, when they flash that security badge to get in the building, that's a lot of data to compile. And one of the other things that makes this makes the employment context uniquely difficult is employees know what they did. You know, when you're dealing with an actual consumer, they may have like a vague idea, but if you're missing something, they aren't going to know, well, I remember last month I logged into this software and I went into that conference room and you didn't include that. So it's a really, really tricky area. So if you're advising employers or you're in-house and you think it's not a big deal that this is delayed, I want to say that it is. And if you're dealing with the employers, please try to make this very clear to them.
Why only a 1-year fix?
So this delay is really to give the legislature time to figure out what they want to do with it. The definition of consumer under CCPA is insanely broad. Did they really anticipate what this would mean in the employment context when you're collecting so much more data? Probably not.
Did Mark write something about that?
I think that he did, which you would find on the analysis channel. Plug there. So this really gives them time to figure out how to handle it. Will this be extended? Will there be some other regulatory structure put in place? I'm not sure. But I think that this 1-year delay gives the legislature a deadline to kind of figure it out. Either you're going to have this duty or you're not. But what it specifically looks like, we really don't know yet.
Complications. So you said the security information.
Right.
You said logging into software.
Sure.
What about disgruntledness?
Disgruntledness is a thing.
Is that a complication?
I mean, it is, because the people that would probably be making these requests, these aren't your star employees. This isn't your award winners. This isn't, people that are really happy and love coming to work. These are, like me, obviously. These are people that have a bone to pick. They have something to prove. There are other ways they could get this information, but CCPA gives them an easy way to just say, give it to me. And it can turn into a fishing expedition, which is another thing that you really have to be aware of. So because of that, I think it's important if you're in-house or if you're advising employers to say, be really conscious of the data that you're collecting and be really realistic about if you're using it. One really common practice for employers to do is everyone that applies, they'll keep their resume on file for the future. Well, do you want applicants coming after that later? Do you want to give them this sort of into your records? If you're not actually going back to those resumes, if it works for you to just reach out to the people and just keep their names or whatever, be really realistic in what you're actually using. Don't collect more data than you need to. It's only going to open you up to problems.
Okay. That's a really good segue, actually. Thank you very much, Dory. We are going to try to wrap up a little bit what we've heard from our panels this morning, what we did hear from Congressman Walden and my fantastic analysts. And I think that we decided to put this under State of the States just because we everyone in this room understands that we've talked about it a lot. There's no federal overarching solution right now. So for state of the states for 1,000, so good. Also, we probably could have included fatigue here from the earlier panel. So ransomware, careless employees, vendor data security, break-ins at your server location, and your spouse's snoring.
Oh, we have somebody here.
Oh. Yes! We have another prize from the lovely Jima, who has now done this twice. Please don't forget to tip your servers, Jima. She'll be here all week. Yes, the answer is, of course, what are things that keep you up at night? I think that Mark, Betsy, and Dory have probably given you all quite a bit of fodder for some nightmares, or at least some late night, watching really bad reality TV while, with the lights low and a glass of wine in your hand. I will use this opportunity, and it's not a completely terrible segue, is that on your tables, not only are there small cards that you can, kind of chat with your table mates and network about some of the questions you have for us or each other. We will be collecting those to see if we can, address some of them maybe a little bit later in the afternoon. There are also cards with a QR code for a survey that's currently out on GDPR readiness. So we've talked mostly today about CCPA, federal and state U.S. Implications of privacy and data security advancing, who's doing what and when, but we do want to know how organizations are dealing with GDPR and how you feel about it. It's a 10-minute survey, and what's really great is if you answer all of the questions on it, we do keep your information private, but you can separately put in your email address and you would get a report of all of the results. So you can see that. But I think that this is the regulatory and compliance team of the Bloomberg Law Analysis Unit saying thank you very much for playing Jeopardy with us. Go that way.